So obviously risk of loss is a very scary concept. If we're going to have a rule that says a buyer has to pay for goods, even though they're damaged in transit or lost in transit, then that's a pretty scary thing for a buyer. As I said, the buyers and the seller can always include provisions for risk of loss in the contract. And so in this lecture, we're going to talk about one of the most common ways that buyers and sellers address risk of loss in their contract. And it involves the use of what are called Incoterms. Incoterms are an abbreviation for international commercial terms. And they are a set of rules that define the responsibilities of sellers and buyers for the delivery of goods under sales contract for domestic and international trade. These terms are published by the International Chamber of Commerce, located in Paris, France, and they are widely used in international commercial transactions. What they are is a standard set of terms that the parties can use and which have a meaning. And the meaning is not only known to the parties, but it's known to the industry as well. And so any judge or arbitrator who's going to hear a dispute that involves something like risk of loss, if the parties use Incoterms, then we know the exact moment at which risk of loss passed. Now, the first Incoterms were published in 1936 as the world embarked on one of the globalization eras of trade. The most recent version of the Incoterms, what we call Incoterms 2010, were launched in September 2010. They became effective in January 2011. The next Incoterms will be published at the end of 2020 and go into effect in 2021. The terms do change over time. The Incoterms are something that will evolve and will change to make them reflective of what merchants need in that current era. So there will be another form of Incoterms, and they may be different, slightly different from what's in the current term. And in fact, we could always go back and use an old version of Incoterms if we wanted to, because the meaning did not change. What we'll see is that one of the things you have to do is specify exactly which version of Incoterms you're using. Now, when I talk about Incoterms, they really are controlling three elements of the transaction. And the first is cost. Who's responsible for the expenses involved in the shipment at any given point in the shipment's journey? Who is responsible for the cost of the shipment of the goods? Because we're talking about international sale of goods, the goods are going to be shipped, maybe across borders, but maybe across oceans, but definitely across borders. The second thing that the Incoterms control is who owns the goods at any given point in the journey. Who has the ability to control the goods at any point in the journey. And finally, arguably the most important for buyers and sellers, liability. Who's responsible for paying damages to goods at a given point in a shipment's journey? So costs, control, liability, those are three areas of the transaction that we are going to depend on Incoterms to provide us with guidance. In terms of Incoterms, of course, you've got to know about insurance. It's essential for shippers to know the exact status of their shipments in terms of ownership and responsibility in order for the buyer and the seller to know who is it that bears the risk of loss. The party that bears risk of loss must arrange for insurance on the goods while the goods are in their legal possession. They're not in their actual possession, but from a legal standpoint, they are. Lack of insurance can result, obviously, in wasted time, lawsuits, broken relationships. So insurance is going to be something vital to your understanding of international business transactions. Now, delivery, when we talk about delivery, that has a special meaning in sales contracts. In global trade, delivery refers to the seller fulfilling the obligations of the terms of the sale. The completion of the contractual obligation on the part of the seller is delivery. Delivery has a, we think of delivery as, of course we know delivery. You go to the store, you buy a bag of chips, and the cashier hands the bag of chips to you, and they have delivered the goods to you. But in a large international transaction, when delivery takes place and how delivery takes place is something that the parties have to concur about in their transaction. Now, we know that delivery can occur even while the merchandise is on a vessel on the high seas, and the parties involved, the buyer and the seller, are thousands of miles away from the actual goods. From a legal standpoint, delivery can occur.